This video is for educational purposes only and does not constitute legal advice. For guidance on specific situations, please consult a qualified attorney. Some portions of this content were created with the assistance of AI.
Imagine you hire a contractor to do roofing work and pay them, but the result is poor quality. That's a breach of contract. Today, we'll explain what it means, the elements you must prove, and the damages you can recover. First, let's rewind for a second. To even talk about breach, you need a valid contract. That usually requires the following elements. First, an offer. One party proposes a deal. Second, acceptance. The other agrees. Third, consideration. Some value exchanged, usually money or services. Finally, mutual agreement showing that both sides intend to be bound. A breach occurs when one party fails to fulfill their obligations under the contract. However, not all breaches are of the same nature or severity. A minor breach is small, like a contractor finishing a day late. A material breach is major. It defeats the purpose of the contract.
Hey.
There's also anticipatory breach, when someone tells you ahead of time, "I'm not going to perform." Courts treat these differently, and the remedies can vary. To win a breach of contract case, you usually have to prove 4 things. First, a valid contract existed. Second, you performed your obligations or had a valid excuse. Third, the other party failed to perform. Finally, that failure caused damages. Each jurisdiction may have slightly different standards for breach of contract, but in most cases to prevail, you must establish all 4 elements. First, a valid contract existed. Second, you performed your obligations or had a valid excuse. Third, the other party failed to perform. And finally, that failure caused damages. If you show sufficient facts for all 4 elements, you have established a breach of contract claim.
Welcome to Justice Matters,
where we discuss the legal issues shaping our world.
Welcome back to Justice Matters. I'm your host, Linda Martinez. Today, we're diving into breach of contract, something that comes up more often than people realize. Joining us is Professor Daniel Harris, an expert in contract law. Professor, thank you for being here.
Thank you, Linda. It's a pleasure to be with you.
Let's start at the beginning. Before we can even talk about a breach, what makes a contract valid in the eyes of the law?
That's the perfect starting point. Today, I'll use California standard jury instructions as an example, but I want to stress that many other jurisdictions follow a very similar approach. Under California law, a valid contract generally requires 3 things. First, clear terms, so everyone understands what's expected. Second, an exchange of value, which lawyers call consideration. And third, mutual agreement. Both parties must truly consent. Courts don't look at secret thoughts, but rather at what a reasonable person would understand from the parties' words and actions.
So it's about clarity, value, and agreement. Once those are in place, how do we know if there's been a breach?
A breach happens when one party fails to do what they promised or does something the contract prohibits. To prove breach under California's model, the plaintiff must show a contract existed, that they did their part or had a valid excuse not to, that the other party failed to perform, that harm occurred, and that the breach was a substantial factor in causing that harm.
That sounds almost like a checklist.
Exactly. And it's designed that way so a jury can work through each step clearly.
Now, a lot of people assume contracts must always be written down. Is that true?
Not necessarily. Contracts can be written, oral, or even partly both. An oral contract is just as valid, though often harder to prove. If a written agreement is intended as the final word, side conversations usually can't be used to change its terms. But if the writing is only partial, oral evidence may still be considered to fill in the rest.
Can you give an example of an oral contract?
Sure. Say you agree with your neighbor verbally that they'll fix your fence for $200. If the neighbor never does the work, that could still be a breach of contract even though nothing was written down.
Interesting. And what about when there aren't even words, just actions?
That's where implied in fact contracts come in. Sometimes the conduct of both parties show an agreement. For example, if someone delivers goods every week and the other party keeps accepting them, the law may treat that conduct as forming a contract.
So actions can speak just as loudly as words.
Exactly. The question is whether both sides intended their actions to create an agreement.
What about situations where people say, we'll put it in writing later? Does that mean there's no contract until the paper is signed?
It depends. If both sides already agreed on the terms and meant to be bound right away, the contract may be enforceable even if the final document was never signed. But if they agreed nothing would count until it was signed, then there's no contract yet. Courts look at intent and how the parties acted.
That sounds like it could get messy.
It can, which is why judges and juries look carefully at the circumstances.
Let's get into the standard for breach a little more. Suppose someone breaks just one small part of a contract. Does that always count as a breach?
Good question. Not every slip-up is considered a serious breach. The law looks at whether the breach was material, meaning significant enough to defeat the purpose of the agreement. If it's minor, say a delivery was a day late but caused no real harm, the contract still stands, though there may still be some damages.
So it's not just about whether a promise was broken, but also about how important that broken promise was.
Exactly. Courts care about whether the non-breaching party still basically got what they bargained for.
Another question we often hear, what if one person does everything right, but the other side refuses to pay or perform?
That's the classic breach scenario. If you've done your part and the other side simply doesn't deliver, then the law gives you a remedy, often damages to put you in the position you would have been in had the contract been honored.
And what if both sides are accusing each other of breach?
That happens a lot. The court will look carefully at who actually performed their obligations, who didn't, and whether one breach excused the other. Sometimes one party's failure justifies the other side stopping performance. Other times, both may share some fault, which makes things more complicated.
So it can become a back and forth.
Yes, and that's where the jury instructions serve as a roadmap. They help jurors sort through the evidence step by step.
To wrap up, whether it's written, oral, implied by actions, or waiting on paperwork, the law has a framework to decide if a contract is valid and if a breach occurred.
That's right. And again, while I've used California's jury instructions as the example today, the underlying principles, clear terms, mutual agreement, performance, and substantial harm are very similar across most U.S. jurisdictions.
Professor Daniel Harris, thank you for breaking this down.
Thank you, Linda.
And to our listeners, contracts aren't just for big corporations. They're part of everyday life, from small repairs to major deals. Knowing the basics of breach of contract can save you stress, money, and time. Stay tuned for more on Justice Matters.
Speaking of damages, the main types include compensatory, consequential, liquidated, specific performance, and, in rare cases, punitive damages. Compensatory damages are monetary awards, intended to reimburse the plaintiff for the actual loss suffered as a result of a breach of contract. Consequential damages are indirect, foreseeable losses from a contract breach, like lost profits or business interruptions. Liquidated damages are a predetermined amount, set in the contract to compensate for a breach when actual losses are hard to calculate. Specific performance is an equitable remedy in contract law, where a court orders a party to carry out its specific obligations. Under a contract, instead of paying monetary damages for a breach, punitive damages are awarded to punish egregious conduct and deter similar behavior in addition to compensating actual losses. Some defenses to a breach of contract include an invalid contract, impossible performance, fraud, mistake, duress, or expired statute of limitations. If you enjoyed this video, please like and subscribe. It helps us create more content just for you.